let's talk about affirmative action. Affirmative action is defined as a deliberate effort to provide full and equal opportunities in employment, education, and other areas for members of traditionally disadvantaged groups. So, of course, discrimination, this type of discrimination was outlawed in the Civil Rights Act of 1964. It prevented discrimination on the basis of race, color, religion, sex, or national origin. But many employers continued to favor white male employees. Just a couple of examples. To be in a union that would negotiate on a large scale for better pay, better benefits for its members, union membership was passed from fathers to sons. So if there had been a tradition of white males working at the job and being members of the union, then black males would be excluded and women would be excluded, and any other racial minority or person with a national origin that is not a part of the group that had traditionally held those jobs would be excluded. And the NAACP, just as it went through the battle of eliminating systemic and law discrimination, legal discrimination, also attacked remedies, and the government embraced remedies through the process of affirmative action. Now, we really saw in the United States the application of affirmative action programs under the Johnson administration. The Johnson administration would not allow you to get a government contract if you were not in compliance with affirmative action programs. They also would not allow government funding if you were not in compliance. Now, if we are talking about organizations, or if we're talking about who applies affirmative action programs, there's really three categories: universities, agencies, and construction firms that are receiving federal funding or federal contracts. If you fall into that category, if your organization falls into that category, then you have to show that you have in place a program that is designed to ensure that all applicants are treated fairly. If you have a program that on its face shows some type of disparate or different treatment, then the burden is on you as the organization to show that you have a compelling reason, because now we're talking about differentiations on the basis of race and national origin, and remember that that is suspect, and requires strict scrutiny. And so you have to demonstrate that you have some compelling reason as the organization to have a policy that results in a particular group getting different or differential treatment. So when we are looking at the concept of affirmative action, I want to reiterate that there are basically two defined ways to discriminate. One of them was part of like Jim Crow laws. De jure discrimination means that it says on the books that black people can't come in here. Um, Hispanics need not apply. We cater to the white race only. It is it is a part of the law that there will be different treatment based on race or national origin. And this was definitely addressed by the Civil Rights Act of 1964 and is vigorously investigated by the Justice Department, Civil Rights Division. But de facto discrimination is a condition where a group of people that have historically been at a disadvantage, sometimes because of laws, sometimes because of attitudes, today have fewer opportunities and fewer benefits because of prejudice and because of economic circumstances. So we are looking at this concept that we call equality of result. So you don't have anything that on its face is showing discrimination, but in its effect, it is. An affirmative action is put in place to alleviate biases, natural biases. You see a certain name on an application and you decide that that's not the person that you want, and you haven't even met the person. My friend was telling me about a study that was done in orchestras, and what they were discovering was that orchestras for years were very male dominated. And they had a question about why that was. And the industry decided that they were going to um, have the people that were evaluating the orchestra, people that were applying for membership in the orchestra or for places in the orchestra, without looking at them. So they would simply listen. And they were noticing that even with them not physically seeing the people, they were still disproportionately, the judges, who were predominantly male because they were members of the orchestra and had traditionally been, were still picking males. And so they went back and they evaluated because they really wanted to see some changes in the industry. And what they discovered was that the women, when they would come in dressed to the nines, would have on heels. And the floors, when they would walk in and out, you could hear their heels hitting the floor. And so they were actually still operating in that bias that males are just naturally better at playing. And so after this evaluation, they started to have the applicants not only come in so that they weren't able to be seen, everyone had to take off their shoes as well. And once they did that, you started to see more and more women in the industry. Because it was not that there was some gender-based superiority in playing instruments. I know when I was in band, girls were always first chair. So it was not that, but it was a bias. And so they instituted with their commitment basically an affirmative action program. They found a way to alleviate prejudice and fewer opportunities based on bias of the people that we're choosing. It's actually pretty interesting. Let's look at some of the affirmative action cases. So first, there is the baseline affirmative action case. University of California Regents, and this was University of California in, I don't remember which of the branches, but it was a medical school. And Alan Bakke was a white male that had worked as a paramedic. And so he was applying and had applied to the medical school at UC. And he scored really, really well on his exams, but he kept being turned down. And what Mr. Bakke discovered is that University of California, in their effort to increase the number of traditionally disadvantaged groups or people that came to their school, had a quota. They actually had a separate interviewing board for whites and for African Americans, because they were trying to improve or increase the percentage of African Americans that were being accepted to the school, to the UC. And so they were guaranteeing that there were going to be a certain amount, because the board that chose African Americans got to pick a certain amount, and then the board that was everyone else picked a certain amount. So they had a quota. And Mr. Bakke sued the school. He said, this is a violation of my rights. This is not equal treatment. And in your effort to help traditionally disadvantaged groups, you are systematically skipping over someone that has excellent test grades. And I don't think it's right. The case made its way through the state courts in California. And, well, I'm saying state courts in California. It may have been federal courts, because it involved university, so they get federal funding. So I'm not sure if it was the federal court system or the state court system. But eventually the case made it to the Supreme Court, the United States Supreme Court. And so the question was, is affirmative action even legal? And number two, was this white male applicant being discriminated against by this affirmative action program, the way that it was being applied? And what the court said was that affirmative action, the deliberate effort to provide equal opportunity, is fine. That there are a lot of reasons that people may not score as well, or and it is fine to have a holistic approach. But what is not okay is to have a quota that is fixed, like they did at UC. And I think it was UC Davis, if I'm not mistaken. And uh, so you could not and have not been able to since 1978 have a quota, a numbered system as a part of your affirmative action program. The only time that it is allowable to have a quota is if you have gotten in trouble. If you have had some written policy that says no purple people will ever go to my school, then the government can enforce, you're going to have a certain amount of purple people coming to your school for this many years. It is a punishment. It can be punitive, but it cannot be a part of an affirmative action program, even though affirmative action itself was not found to be a violation of the Equal Protection Clause. Then in 1995, there was the case of Adiran versus Pena, and I'll be the first to tell you that this was not one that I was familiar with prior to teaching this class. But there was a federal program that reserved 10% of federally funded construction projects for minority-owned firms. And the Supreme Court said, again, this is a quota. It's fine to have an affirmative action program. It is fine to say that you want to increase the number of businesses that are minority owned in your calculation. It's even fine to take into consideration that the organization is headed by a minority. But what is not fine is a fixed number. Then a few years later, there was the Grutter versus Bollinger case. And this involved the University of Michigan. So this is, of course, a state school, and specifically it was the University of Michigan Law School. They had a law school admissions policy, didn't have a quota, didn't have a certain percentage, but it did take race into account, along with other factors such as work experience, extracurricular activities. So they looked at all of these and said, we are really trying to have a more well-rounded student body, a more diverse student body. So we are going to look at all of these factors to make a decision. And the court actually upheld in 2003 and reinforced that if you have an affirmative action program that takes race into account along with several other things, that is fine. The most recent serious challenge to affirmative action programs involved University of Texas, but it really affected all state schools in Texas. I'm going to first just tell you this. When I went to Texas A&M, I got a scholarship that was called the Presidential Achievement Scholarship. And Texas A&M didn't even desegregate until 1968. They the first African Americans to go to the school, to play on the football team, to be in the corps, to play in band. Many of them are still alive. So A&M was really late to the party as far as their segregation, and part of that was because A&M, but really every state school had in their system an African American school. For University of Texas, it was Texas State University. For Texas A&M, it was Prairie View A&M University. But A&M was having a really difficult time desegregating, bottom line. And so in an effort to change that and change it quickly, A&M came up with a scholarship that was designed to be given to high achieving African American students, and that they said it on there. That was what it was for. The University of Texas had one that was quite similar. I got that one too. Um, and the A&M scholarship, I still don't know why my dad made me go to A&M, but the A&M scholarship paid a little bit more per semester. It just paid it 4 years, while the one at University of Texas paid, it was the same amount, but it was spread out over 5 years. That was really the big difference. Um, and when I went to Texas A&M, good heavens, they were aggressively recruiting. They were going to schools. They were finding the African Americans that were in the top 10%. And they were going, where are you going to school? No, you're not. You're going to A&M. And they were aggressively recruiting. Because they said if we're gonna let these African Americans in, we want the best and brightest. And that was the effort that they were making, and they were competing with University of Texas for those students. But eventually, there was a lawsuit that said that a state school cannot offer money or scholarship money exclusively to one race. And that suit, the plaintiff won, and so they're no longer able to offer that scholarship. Private organizations can offer scholarships, but state schools cannot offer minority only scholarships. And I can tell you that the enrollment of African Americans at Texas A&M and University of Texas and University of Houston and Texas Tech really went down. For whatever reason, it went down because no one was offering that money anymore. And the environment at Texas A&M was not one that made African Americans just really chomp at the bit to go. And so it was literally that offer of basically that paid my tuition in 1988. From 1988 to 1992, never took out a student loan. My tuition was paid. So in 2016, Miss Fisher filed suit against the University of Texas because once that their scholarship went away, they had to come up with another way to increase diversity on their campus, and that was their goal. And so University of Texas and Texas A&M and University of Houston and Texas Tech and Texas State, I think I've got all the systems in Texas, all started programs where they were looking at holistic evaluations. So first they had that top 10%. You're in the top 10% of your class, no matter where you went, you are automatically admitted. Okay? But then for those students that were not in the top 10% of the class, they started to do this evaluation that at University of Michigan Law School took race and experiences and extracurricular activities and other things into account and not just your GPA and your SAT scores. So again, they were looking at this holistically and with a stated goal that they were trying to increase the diversity of the student body. Because it was a problem. It was a problem once they were no longer able to offer those targeted scholarships. And so Miss Fisher sued the school because she was a white female and she did not get accepted. She was not in top 10% of her class. She had higher test scores and a higher GPA than many of the people that were admitted, and she said that this was discrimination. So the case made its way to the Supreme Court, and there was some indication. I remember Justice Scalia making a comment that, maybe black people just weren't as talented as whites, and he certainly did not like affirmative action. So there were all kinds of indications that Ms. Fisher might actually be successful. But in between the time they played with that case, they sent it back down to the Fifth Circuit and said that you did not look at this the correct way. You did not apply the compelling interest strict scrutiny test, because this does have to do with race. And so this bounced around the court system for years. In the interim, Justice Scalia passed away. And the case makes it back to the Supreme Court. They had already granted cert on the case after and heard the case after he passed away, but before a new justice was put on the court, because Mitch McConnell wasn't going to let a new justice be put on the court by President Obama. That just wasn't going to happen. They held that position open, that seat open for what, 10 months, until President Trump was elected, and then President Trump ended up nominating Merrick Garland. No, Merrick Garland was the guy that didn't get a hearing. So, but President Trump ended up nominating the person that filled that seat. And so the court, when they voted with an even number of people, 4 people were for striking it down, and 4 people were against striking it down. So if there's a tie, there's no person that you take it to as a tiebreaker. The rule is that whatever was decided at the lower court stands. And the lower court had decided that this was allowable, and that this affirmative action program that took so many things into account, including your race or ethnicity, was fine. And so by the narrowest of margins, it ended up being upheld. Now, had Justice Scalia been alive, then it probably would have been a 5-4 decision, and the policy would have been overturned. I can't think of the right version of struck. So, those are the affirmative action cases. Remember, the biggest thing to remember is that quotas have been a violation of common law since 1978. And you can wrap it up and try to say not a particular number, but a percentage. But Adirond said you can't even do that. Quotas are a no. But it is okay, and that was reaffirmed in Grutter and in Fisher, to have an affirmative action program with the stated goal of increasing diversity. And as long as race is not the only factor that you are considering, you are considering race and well-rounded and work experience and a myriad of things, that it is okay. So that is the law as it stands right now on affirmative action. There have been a couple of cases that one at Harvard and one at Caltech, where Asian students have sued because they feel as if they are being discriminated against because their test scores are so much higher than the people that are being admitted. And Harvard has an affirmative action program. Caltech has an affirmative action program. A lot of schools, private and public, have affirmative action programs. And so the argument of these students is, if you were looking at pure merit, if you're looking at pure performance, then we would be let in. And so how are you allowing students with much lower scores to be admitted based on your program? So that it's discrimination. But so far, though, the two that have made it to the court system have both not been successful. So we will see. We will see. Now have a 6-3 conservative majority on the Supreme Court. So my guess is, just like in the 60s when all the criminal defense attorneys were trying to get cases to the Warren Court, I think that people that are opponents of many things, including affirmative action, and Roe versus Wade, and all kinds of things, are going to be filing suit, trying to get cases to this court, thinking that they will be successful where they had not been successful in years past. It matters who's on the court. It matters. All right, so that is the affirmative action lecture, and what is left is going through the struggles of other disadvantaged groups.